Hello, hello, hello. Hi, everyone. Good evening. Thank you for joining me. This is Ifama Odunlami, immigration attorney from the Odunlami Law Firm in Cedar Knolls, New Jersey. Um, as you know, our law firm serves clients from all 50 states. So I see that you guys are joining me. Thank you for joining. Please let me know that you're with me on the comments. Tell me where you're joining from. And guys, I have some good news. So I want to share with you. And then I have a really quick topic I want to talk about because every time something comes up in during a consultation or during sometime during an interview or something, and it's strikes me as something I want to talk about to you guys, then that would be the topic of my discussion. But I'm always happy to talk about something else that you guys want to talk about. Just DM me and tell me what topics you want to talk about. So thank you guys for joining me. Thank you, thank you. Hi, Ayadele. Thank you. So, guys, listen to this. I don't know if you have heard this before, but USCIS is opening a new service center. And you may wonder to yourself, well, why is this news? Guys, this is good news because they're trying to cut back on the backlog. And they're going to be working on this new service center. Is first of all, it's going to be a virtual. I think it's they say it's a virtual service center. They've already reassigned 150 employees, and they plan to have over 300 to staff this center. So, how is that relevant to you? Well, it's relevant to those who are VAWA applicants, U visa applicants, people who are removing conditions. And these people, a lot of them have been in severe backlogs, like the removal of conditions. People are getting 48-month extension letters. We're not even sure what that means. Does that mean it's going to take them 4 years to make a decision to remove the conditions? We're not sure. Or those who have been waiting for their VAWA cases. VAWA is taking about 33 months, to get a decision on an average, or people who have been on the line forever to get the U visa. So if this pans out the way we're hoping it's going to pan out, this center, which is called HART, is an acronym, capital HART, stands for Humanitarian Adjustments, Removing Conditions, and Travel Documents. So these are the types of cases, these 4 types of cases, these are the types that this new center will be working on. So I think this is great news. And even greater news, guys, is the fact that, guys, we're getting so many green cards without interviews. I mean, a lot of people, attorneys who've been practicing for a long time to this, they have never known this to happen. And I think part of the reason is because of the backlog. The backlog has been so severe that a lot of people are suing USCIS. My office has sued a couple of times, and we've been successful. In fact, as soon as we file a lawsuit, where within a week we're getting a response. Now, the response may not be an approval. In our case, they're both approvals. But basically, we're telling USCIS that they need to move on and make a decision on this case. Is taking too long. So today, what I want to talk about is removal of conditions. I'm happy to answer your questions. So thank you for joining, Portia. Thank you for joining, Iba. And I see Finance Shandy. Hi, Finance Shandy. He says, how has your day been? My day has been great. Okay, thank you for asking. So now let's talk about removal of conditions. Removal of conditions, that's when you marry a U.S. citizen or you marry a green card holder and you get a temporary green card, only good for 2 years. And the reason you get a temporary green card is because your marriage was less than 2 years when your green card was approved. So that's not a permanent green card, that's a temporary green card. So typically, what you're supposed to do is 90 days before the expiration of the green card, you're supposed to file the form I-751 and remove the conditions with your spouse. That now note, I said I-751, not form I-90, because this is a mistake. This is a common mistake that a lot of people make. When their conditional green cards are expiring, they file the form I-90, which is a renewal of your green card. That's not the form you're supposed to file. You're supposed to file the I-751. So the I-751 is the removal of the conditions. And if everything's working well with you and your spouse, you guys are living happily and everything, well, your spouse and you're supposed to remove it jointly. And typically, sometimes they'll call you for an interview because now they get a chance to look at your relationship again. But the good news is, in a lot of cases, they are waiving that interview if USCIS feels that your marriage is legitimate. So what happened was during the Trump era, the Trump administration believed that every marriage was a fraud and basically wanted to interview every single person. So that created a huge backlog. Then with COVID, the backlog was unsurmountable. You guys, I don't know if you may not know this, but there was a time when you file to remove the conditions, they'll give you a 12-month extension letter because typically it would take them 5 to 6 months to make a decision on your case. And then it moved to 18 months. And we were thinking, oh my goodness, this is so long. And then it moved to 24 months. They'll give you the 24 months extension letter. And now it's 48 months extension letter. It's so ridiculous, right? So if you're filing to remove the conditions, you really want to do a great job putting your bona fides together, the proof that your marriage is legitimate, that you entered into it in good faith. You really want to put it together so that if you can avoid that interview, waiting for the interview, then that would be great. Now, there's some people that, unfortunately for them, the marriage is not working out. And the reason I'm talking about is because even though I talk about this quite a bit, I'm always surprised to get a consultation where somebody is crying that, I don't know what to do. This person is treating me so badly, or he has filed a divorce. What do I do? And I always tell them, if he wants to file a divorce or she wants to file a divorce, let them. Because a divorce is one of the waivers. A waiver is something that allows you to get your green card without having to file it jointly with your spouse. There are 4 waivers, right? There's divorce. So if your spouse is threatening to divorce you, go ahead, let them do that, because all you need to prove is that it was a real marriage. You basically have to submit the same stuff that you submitted when you were, when you tried to get the green card the first time, showing it's a valid marriage. You want to show proof of financial commingling. You want to show, proof that you guys are doing things together. You're holding yourself out in the public as a couple, and the whole shebang. Show that you have, you live together. You continue to live together. All that stuff. So the only thing with a divorce waiver is you have to have the divorce approved to use it. So if your spouse files for a divorce and they call you for the interview and the divorce is not approved, that could be a problem because you can't use divorce waiver. It has to be approved by the time you call for an interview. So that's why I tell people, if somebody wants to divorce you, you want to file a divorce, really get on it, because some of these courts, there's a delay in some counties. It's taking them a long time to get the divorce process through. So don't feel threatened or feel bad if your spouse wants to divorce you. If this is what he wants and it's not working out anymore, you can still get your green card, okay? Let them file the divorce. You move on, get your green card, move on with your life, all right? Now, another waiver is the waiver of extreme cruelty or physical abuse. Doesn't have to be both of them, right? This is like the VAWA, Violence Against Women's Act. It's the same idea. But the difference between VAWA and this is that with VAWA, you don't have a green card. You don't have any green card. So you're using VAWA to get your green card. Now with the waiver, you already have a temporary green card. You're trying to show abuse so that you can get your permanent 10-year green card. So it's the same thing. The person is treating you badly, sometimes threatening to call USCIS on you, threatening to hurt your children, threatening to hurt your dog, threatening not to show up to the interview. It could be physical abuse. It could be emotional abuse. Guys, I'm telling you, some of the things I see, pictures of abused victims or the stories I hear, it really tortures my spirit. I kid you not, because, when you hear the pain in somebody's voice, what they're going through, um, that's why I'm so grateful that I'm in a position to help people know that there's a future. You don't need to be in this horrible relationship. Even if you think you don't have any proof, we work with you to look for proof. And sometimes your best proof is your story, right? What happened? How did it happen? So now that's one. And of course, if you're going to show that there's abuse in a relationship, you don't have to wait to the expiration of the green card. You don't. So as soon as that relationship is not working out, call it quits. Same thing with a divorce. If the divorce comes through before the 2 years, you can go ahead and file to remove your conditions. Okay. Now, the third waiver is the waiver of death. If your if your U.S. citizen spouse or green card holder spouse has unfortunately passed away, well, they can't remove the conditions jointly with you. They're not here anymore. So in that case, you would file to remove it on your own, without them. And again, you have to show it was a legitimate marriage. It was a good faith marriage. So we had a case where our client had been married for such a short period of time. I think it was like 2 or 3 months. So they hadn't even acquired much in terms of bona fides, right? But we were able to get her green card by showing, we had pictures of them when they were dating. We were able to show the dating process. She didn't even have proof that he was a U.S. citizen. We had to get the proof, and we got that proof from USCIS. We filed a FOIA, and we got that. So, you can continue with your process. Now, the fourth process is the extreme hardship. And out of this four, this is the only this is the only waiver that does not require you to prove it was a bona fide marriage. But what you're required to prove is that, you're going to suffer extreme hardship if you had to leave the United States. And that extreme hardship had to have happened during the conditional residency period. All right. So we're talking of, are you in a divorce process? You have a child, that you can't, you may not see if you had to leave. Is your country at war? I mean, there are many things that you could show to prove hardship. So let's talk about the reasons why some joint conditions get denied, because this is really important. Because if your conditional, your I-751 is denied, you could find yourself in removal proceedings, right? So just because you have a green card doesn't mean that they cannot deport you, take your green card away from you. So let me talk about some of the reasons why your I-751 can be denied. Number one, it may be denied because you didn't submit enough evidence, right? It may be denied because you filed too early. So it's 90 days. If it's a joint removal, it's 90 days before the card expires. If it's abuse, you can file as soon as the abuse is going through. You have all your information. If it's divorce, same thing. Okay, or you filed too late. Your green card might have expired and you didn't get to file it. Now that's not a problem as long as you can just articulate a good reason for why you didn't file. Okay, they're not really they don't really give you a really, really hard time on that, but you just have to explain what happened, right? Another reason is if they show that there's been criminal activity, you've committed a crime during this period, so that might be a reason to deny your I-7 your removal, the conditional removal, and send you to immigration court. Another one is if you don't attend the interview for one reason or the other, they could deny you because you didn't show up. You or your spouse or you alone didn't show up. And the other one I want to talk about is if USCIS believes that your marriage is not real, and that's the thing is when you remove you're fighting to remove your conditions, that's another chance for USCIS to take a look at your relationship. But a lot of people think that just because they've gotten a green card the first time, that somehow they're going to be waved through. And no. the I-751 interviews are actually harder sometimes than the marriage interviews. I kid you not. When we have those, the removal of conditional interview, we take everything seriously, but we really, really make sure that, because we know that USCIS recognizes the fact that this, if they give you a green card, it's going to be a 10-year green card. So they're really looking through your application. And sometimes when you've gotten the green card the first time, you might not have been able to show, you might have, you were just newly married, so you might not have a lot of information that they could look at. But this time around, you've had a green card for 2 years. There's no reason why you can't have the joint taxes. You can't have proof that you live together and all that stuff. So it's actually, you have to take that seriously, right? And then now, a question I get all the time is, if your I-751, you filed to remove your conditions, and you haven't gotten, and you get the extension letter, but the extension letter maybe took you a while to file, and the extension letter maybe gives you 18 months, but after 18 months, you still haven't gotten your card. There's still been no adjudication. What do you do? Well, in the past, you would need to do make an InfoPass appointment and go and get your card stamped. Now, there's a new thing that USCIS is trying to put in place, where you don't even have to make that InfoPass appointment, where you can get it by mail. So that's really, really awesome. I think they're really trying hard to really work on this backlog, because it's really devastating a lot of lives. So let's see. I will answer questions shortly. I just want to make sure that I get through everything I want to talk about. So now something else I want to talk about is when you have a conditional green card, right? If you file jointly to remove the conditions with your spouse, right? And then after you file jointly, the relationship breaks up. You really should update USCIS with either, either whether it's abuse or whatever it is, because there's a story about somebody who traveled with his girlfriend, not his spouse, and USCIS questioned him as to who are you traveling with. And instead of being forthright and saying that he was traveling with a girlfriend because his relationship was no longer, wasn't valid anymore, he lied and said, he was traveling alone. And of course, they pulled him into secondary inspection, and they found that he was with somebody else instead of the person he filed a joint removal with, and that caused him a lot of problems. So if you file jointly to remove your conditions and your relationship is not working anymore, and you qualify to file under any of those waivers, you really should update USCIS with those. So guys, let's answer questions. I don't see any questions here, but Portia says VAWA. Yeah, Portia, what about VAWA? Let's talk about it. Iva says, good evening. Hi, Iva. How are you? I hope I'm pronouncing your name right. And let's see. Portia says, NOID. NOID, failure to prove that the marriage is legitimate. Portia, people get annoyed all the time. Notice of intent to deny. Basically, USCIS is saying they want to deny this case, but they want you to explain why they should not deny it. Meet your burden of proof, the hardship choice. So my office does a lot of responses to NOIDs, and we've been very successful. So you really want to use an attorney on this, really, because I can't really, it's hard to advise somebody on a NOID without knowing the basis for the NOID. Typically they will break down all the reasons why they're sending you a NOID, and you have to address every reason, explain. And sometimes the explanation is, maybe the question was confusing, maybe there's some other reason, but you really need to discuss it. And sometimes it could be, oh, you don't have enough evidence. Well, in a VAWA case, VAWA requires credible evidence only. And sometimes USCIS forgets that that's the benchmark for a VAWA submission, credible evidence. So if you have a NOID, you want to reach out to an attorney and have them help you respond to it, okay? All right, guys, who else? Any other questions? I don't think that there are a lot of questions here, so I will sign out. But I wish everyone a great evening, and I will be back to talk about any other immigration topic. Okay? Take care, guys. Bye-bye.